All right, I think it's recording now. Perfect. So let's go ahead and Professor Garapujol, welcome back. This will be our second of 5 labs. And what I'll do is I'll begin by doing a screen share. What I've done is I've updated the syllabus to reflect our new schedule. And rather than try to squeeze in a makeup class, as I was thinking originally of doing, as you can see here, what I've done is I've updated and I've just pushed back all the labs. You know, we still have a time slot for for today. If you're in sections 1 and 2, if you're watching and you're in the other sections, those dates have been rearranged by the university due to the football game. And then what I'll do is the last lab, I'll find a date towards the end of November. Again, this will all be optional and recorded, both Zoom and in-person options. And as we get closer to November, I'm working to find a date. So that last class, normally what I do is I talk about what's going on in, for example, today we'll talk about Tiger King and to use the Tiger King docudrama to illustrate fundamental aspects of our common law. I'll talk about, Facebook today, what it's going through. Its stock value has basically plummeted to half of what it was at its peak in January of this year. And then we'll also talk about a little bit about the JFK and as documents continue to be released by the government relating to the investigation of the JFK assassination. So that last lab is just putting everything up to date and use that to talk about business ethics and corporate governance generally. So we'll figure that out. So what I've just done is just kept the schedule the same and just moved the actual lab. So, we would have been doing our 3rd lab today, but no, we had the storm. I know the university didn't close until the day after our class, but our class meets late in the afternoon and we have students for the state. And I thought just out of the abundance of caution, we would just wrap up, close early, make sure everybody moved to safety, and we'll continue to be flexible. Also, as I posted on the homepage, I'm going to push back all the deadlines. It means I'll have a lot more grading. I won't be able to stagger the grading the way I like to. But if you get your stuff in early, I can grade them early. But I'm going to give everybody until December 2nd because everybody's circumstances are a little bit different. Hopefully, you weren't negatively affected at all by the storm, or if you were, maybe it was a temporary loss of power, but others, unfortunately, were completely devastated in our class, and have, so let's just do across the board and make it simple and give just flexibility built in for everybody. And we can just try to move forward the best we can, at least in this class, given that it's, although it's not an elective, most of you are going directly into industry, not into law school. So I want to be flexible there. Okay, with that, what I'm going to do is, what I normally do here is, the common law, what's so fascinating about the common law is that it originates in England in the Middle Ages. And then as the British Empire expands, there's something called the Act of Union between England and Scotland and Ireland later in 1801 is going to become part of the United Kingdom. And then and today this is, we look at this with different eyes, colonialism and imperialism. But what happened with the British Empire is as it expanded, the North American colonies, Canada, New Zealand, India, and what is today Pakistan, parts of Africa like Kenya, East Africa, and Zimbabwe. All of these, what we call today Commonwealth countries, have a common law tradition. And so what we're going to study in this module is really kind of cool because it's something that it's not proper to say international, even though it's, a lot of countries share the so-called common law tradition. But each country will modify and develop the common law as per its own needs. But what makes the common law, quote unquote, common, what the common thread, if you will, these countries. Oh, by the way, I didn't even mention Caribbean Commonwealth countries like Jamaica and Trinidad and Tobago and Bahamas and Bermuda and others that are part of the English Commonwealth, or this Commonwealth of nations that also have the common law. And what we mean by common law are judge-made principles. When judges decide cases in a common law country, judges are applying principles and legal doctrines and rules. And what happens is, because of the principle or the doctrine of precedent, binding precedent, in Latin, we call this stare decisis. Let the decision stand. And this is one of the reasons why, for example, the Supreme Court 6-3 decision overturning Roe versus Wade, though that's not common law, that's constitutional law on privacy rights, equality, etc. But decision to overturn a previous decision of the Supreme Court. A lower court can never overturn a decision of a higher court. Higher court decisions are always binding on the lower courts. But a high court, every so often, right, has the option of, though it normally tries to stick to principles of stare decisis, and the idea here is you want the law to be predictable. And you want people to be able to plan their affairs. So this is really fundamental for business. You have to have stability and rule of law. And what rule of law is not so much substance as it is procedure. You just have to have stability. Even if a decision was made wrongly, even if you disagree with Roe versus Wade, for example, the idea is, well, the court made the decision, and so let's leave it alone. This is one of the reasons why the decision, earlier this year in the previous Supreme Court term, Dobbs versus Mississippi, is a very controversial decision, not just because of the subject matter, but because it's one of these decisions that overturns a precedent. And so so it can be analyzed on many different levels. But what I want to do is focus on today, though, with the emphasis on business law, is the common law in three areas that apply specifically to business: property, contracts, and torts. Torts are injuries or accidents. So you really can't have business. You really can't have, free markets and industry and competition unless you have property rights, unless you have contracts that allow people to make deals with each other and transfer property rights, and unless you have rules for dealing with harmful wrongs or wrongful acts, when people have to pay compensation when somebody gets injured. And let me just tell you right now off the bat, torts, property, and contracts are 1 to 2 semester courses at every law school in the United States. I can't speak for legal education in Australia or Jamaica or India, but I can speak for legal education in the United States. And so we're talking about these 3 subjects that we're going to study will occupy anywhere between 4 to 6 law school semesters. So what I'm going to do is break it down and simplify. Now, this is one of the reasons why personally I do not like this new format, because we have such limited time. Whereas before, I could go into more detail into each of these, 3 areas of the common law: property, contracts, and torts. What I'm going to do is just share the survey results for this common law module, and then use those survey results in order to teach you some of the most important ideas of the common law. But if you remember one thing, it's the idea of stare decisis. That's courts are not, precedents are binding on lower courts. And even when a high court makes a decision, it's supposed to respect, generally speaking, decisions that have been made in the past. Now, there are a set of criteria for when the Supreme Court, for example, can consider overturning a case. These are the things that you really would go into law school. For now, I'm not going to go into it because it's so rare. Even the Roberts Court, that is to say, the Supreme Court, since Chief Justice John Roberts has been, helm of the court back in 2005, there have been less than 20 times that the Supreme Court has overturned the precedent. So it's rare, even when you have a court that's willing to, change the law in a certain direction, as has been accused. But let's go ahead and jump into the survey results. And what I'm going to do is I'll do a screen share. And what you want to do here is, let me just pull up the, actually, I'll do the screen share now. Let's see here. Let me go into Zoom. So far, we're so good. Again, if we do get disconnected, I'll implement my backup plan and just stay on the line. So let's go ahead and do a screen share, and I'll just do a screen share. We'll go into the module and we'll pull up the the survey. You can either pull it up by going into assignments and finding it there, or you can go, into the module. And we're still on module C since we've extended this part of the course. And as you can see, I've already introduced, hopefully if we have time at the end of this class, I'll introduce the next module, which will be the law of ideas. To me, that's the most important module, if you're an entrepreneur, startup, or even an established business company. But for now, let's talk about the common law, which, like I say, involves property, contracts, and torts. Now, if you haven't done any of the assignments yet, you should do the survey. I've extended all the deadlines, but you should just get this out of the way. Survey is a graded survey. You get full credit no matter what, right? We're going to continue that way. There's a quiz, open book. For my remaining quizzes, I'll remove all the time limits, just keep it open book and remove the time limits and just keep it extended, just to keep it fair for everybody. And the discussion post, I talk about Oliver Wendell Holmes and probably the most famous quote about the common law. The life of the law, though he's referring to the common law, is not about logic, it is about experience. And I think after today's class, I also have a second part about illegal agreements. And so we'll take a look at that, corner of the law, which I find so interesting, the underground economy and how it relates to. And the part of this is my interest in developing countries and developing economies. But anyways, let's go ahead and look into our survey results and use that as a way of sharing with you the main aspects of the common law. So I'll do survey statistics. By the way, in the module, I have blog posts sort of for each of these 3 areas of the common law, which give you in writing a very nice summary or introduction. Now we have a large class, so okay, good. We got the survey. Let's take the survey results are. Now, my first question has to do with property rights and how do you acquire property rights? This case, Pearson v. Post, is a very famous common law case, and it's studied in every law school in our country. And so it also elaborates some important principles that I'm about to share with you. But the basic case is you have Pearson, who was the first person to have physical possession of the fox, the wild animal, if you will. And you had Post, who's actually hunting the fox with hounds. And he was in hot pursuit, if you will, when Pearson just shows up out of nowhere, uninvited, and grabs the fox. And so the question is, if there's a dispute about who owns the fox, if the parties cannot come to a mediation or an agreement among themselves as to what are we going to do here, hey, I was hunting this fox when you showed up, you, the intruder, you, Pearson, and you just grabbed the fox. Pearson's going to say, no, it's my fox. I grabbed it first. I don't care how long you were in pursuit. And so I like to see what the class thinks about who should win the case. And then I'll share with you how the court decided this decision and why it's so important. What's interesting here is the class actually agrees with what the court's decision was. The court ruled that Pearson, as first possessor, should win the fox, ownership of the fox. Now, I should say, before I move on, this is, in some ways, this is an anachronistic case, obsolete, if you will. Today, fox hunting is illegal. To the extent hunting of wild animals is permitted, you have to have a license, all this kind of stuff. It's highly regulated. But one of the ironies is that fox hunting, both in the United States and even in England, where fox hunting originated, right, is illegal. But back in 1805 or whenever, 1807, when this case was first decided, this was an open issue. There was no people had to, a lot of people had to hunt for their own food. And what's an important detail in this case is that the wild animal was being hunted and was ultimately, captured, right, on unowned land, public land. So that's why you have this ownership dispute. Generally speaking, when you find, let's say, treasure on, someone's property, or you find a, hunt an animal on someone's private property, the treasure or the property belongs not to the finder. Legally, it belongs to the person on whose property it is. That's sort of, a general common law rule that judges have applied over the centuries. But what happens when you hunt a wild animal, on public land? So that's why this was a novel case. Now, the reason why this case is so important is because there's a dissent in calling Pearson a saucy intruder, and the dissent and the lower court judge would have ruled for Post, the guy who was hunting, because the idea is, and a 22% of the class voted for Post because he spent a lot of time and effort, in pursuit of the, and so don't we want to reward that time and effort that was put into the pursuit, and so the idea is, and this is why this case is so important, because there's two types of legal norms or legal rules. One are black letter or clear cut, bright line rules, simple and easy to apply, like, hey, whoever grabs the fox first, physical possession, capture, right? It's a bright line rule. And times in the common law, you'll see courts try to come up with simple, clear-cut, bright line rules. The other possibility, though, for resolving a dispute are what lawyers call and judges call, law professors, flexible standards. A standard would be a norm like whoever puts effort into, hunting the animal gets to own the animal, regardless of whether they've captured it yet or not. The big difference between a bright line rule and a general standard is that a bright line rule is simple and easy to apply, whereas a general standard can give way to a lot of gray areas. Think about it, right? If you're going to go, for those of you who voted for Post, the guy who was hunting, the guy who put time and effort, into the hunt, how much time and effort? Like, what if he had just started 5 minutes, into the pursuit? Is that enough to adjudicate ownership? Or those of you who voted for Pearson, the first possessor, what if this guy had been hunting for 10 hours, and was just about to capture the fox, wear it down, after 10 hours, isn't that, you call dibs on it, you put all this time and effort, shouldn't you get it? Shouldn't that fox be yours? Well, that's the problem with general standards, is where do you draw the line between 5 minutes and 10 hours, between those two extremes? Now, that's the advantage of a bright line rule, right? It's easy, simple to apply, boom, we're done. Problem, though, with bright line rules is that they can be unfair and unjust. Think about it, right? The guy who put in Post all this time and effort to try to capture and then hunt the fox, right? That seems really unfair to him, that, after I put all this time and effort, invested all this time and effort. And if you think about it, why do we have law in the, how can we have a prosperous society unless we have laws that reward time and effort, spent on people doing productive activities, right? Business. And so, a general standard, you can do justice. It's more flexible. But again, the problem is you have this trade-off, built-in trade-off. So sometimes, here's the larger lesson. Whether you remember, Pearson v. Post, unless you take the bar exam or go to law school, you'll never have to remember that case for the rest of your life. But what I do want you to remember is the difference between simple, bright line rules. Think about a speed limit, right? Gemini Boulevard, Libra, right? What is it now? 25 miles per hour. That's a bright line rule. Versus like a sign. I just saw this sign yesterday. It said, drive carefully. What does that mean? Drive carefully, that's kind of a general standard. So, and what you have is, with the common law, and law generally is a mixture of simple, clear-cut, bright line rules on the one, and sometimes general standards, flexible standards. And we'll see so many examples now in the rest of the course. So let's go ahead and continue with our survey. I'll continue with the screen share. Fortunately, we've stayed on the line here, so we'll continue. the next question is, oh, so this is a to show you contract law, when promises are legally enforceable. And this is pictures I've taken. If you look closely, B and D are the same, but I'm asking which of these are legally enforceable, I just have curiosity. And let's see what the class thinks. There's 5 options here. And C by far has gotten the most votes. And C actually is the correct answer. But why is that? Why is that? And if I wish I could expand this a little, make this a little bit larger, but if I do, it's going to just distort it. Let me see. Let's try. What does C have that the others don't have, or vice versa? And I'll just tell you. First of all, let me just pause this and just say that this is important, because when we talk about contracts, what we're talking fundamentally is, when will the law enforce a promise? So the idea of promises, of agreements, both formal and informal, that is what businesses are built on, both small and large. Contracts are really, really important. And so the question is, when will a promise be legally enforceable? Like, when will a promise for a reward, if you find my lost pet, when will law compel me to, keep my promise? And in the case of these examples, only C has oops, let me do the share. And I'm sorry, I can't make it larger. It'll just distort it, but only C has an actual dollar amount. And you can see that the owner of this animal really loves his or her pet, is willing to provide $1,000 in a reward. That would be legally enforceable. All the other ones don't really have a dollar amount. Some don't even have the word reward, or they have the word reward, but they don't specify a dollar amount. That's one of the fundamental rules of the common law. Lawyers and common law judges call it consideration. And what consideration means, for a promise to be legally enforceable, at a minimum, there has to be something of value being offered. Just what's called a naked promise. I promise to give you a reward if you find my lost pet. There's nothing definite about that, or going to the social network. We'll go back to that example when we look at the law of ideas in our next module. You remember in our first module, or our first lab, we talked about face mash, but going to the social network, right? It's the difference between Mark Zuckerberg saying to his best friend, Eduardo, hey, let's be partners. And I'm going to give you, if you become my partner and you provide me some, you invest in my company, I'll give you 35% ownership stake in the new venture. Right? That is a definite amount being offered, 35% of a new venture. So it's something of value. Normally it can be a dollar amount, or it can be an equity stake, or it can be a thing, like a or something like that. Compare that with Zuckerberg's relationship with the Winklevi, the Winklevoss twins, where the Winklevoss said, hey, this will be an opportunity for you to, you, Mark Zuckerberg, if you work on our website that we have in mind, this will be a chance for you to rehabilitate your reputation, especially after the face mash incident. And so, that's not really, a reputation is something of value, but notice it's not the Winklevoss twins. They can't really give that to Zuckerberg, right? That's really up to his fellow classmates at Harvard, whether they're gonna, what they're gonna think of him, if he does work on this new website. But if on the other hand, the Winklevoss twins said, hey, Mark, here's $500 if you help us finish our website, or let's our ownership, 4 ways. Divya, the 2 Winklevoss twins, and you, Mark. Let's all get 25% of the new venture. That would be something concrete, something of value. It could end up being worthless. You know what I mean? Because the company could fail, but it's something concrete. A specific ownership stake, equity stake in a new venture. And so I want to share with you the next example, though, And to show you how the common law evolves, it's a very famous case, the PepsiCo case. It's in the reading, and I think it's my next survey question. And I've included the actual Pepsi ad, that aired during the Super Bowl. I think it was 95 Super Bowl. And I need to research that, because it might even been a Super Bowl that Whitney Houston sang the national anthem. It's still considered the best performance of all time, and deservedly so. But the point is, in this ad, and if you have a chance in the module, I won't play it now because, as you know, I've already got disconnected a couple of times. So I may run out of time, and I want to do all the questions. But what happened in this Pepsi ad is that with Pepsi points, right? The ad, you could get sunglasses, a leather jacket, and at the very end they say, 7 million points, right? And you can get the Harrier jet. And it looks a lot like the case here, right? They're specifying, what the reward is, and if you have the 7 million Pepsi points, if you have 7 million Pepsi cans, you know what I mean? What ended up happening, though, this guy Leonard, in the case that I assigned in the textbook, he looked at the rules of the game. Back then, you had to go to the store. Now it'll all be on the internet, but and the rules said you could also buy Pepsi points 10 cents each. So what he did is he got a group of friends, a group of investors, if you will, and they each, 10 cents, 7 million points, $700,000. They wrote out a certified check for $700,000, Pepsi points. Where's our jet? And the reality is, of course, this is a military, this is a very sophisticated aircraft. It can land and take off like a helicopter, but it's a jet, military jet. Its value at the time the commercial was aired was $23 million. Today it'd be over $100 million. So it's so really what these guys wanted was the $23 million. Just give us the cash equivalent, because you said we're 7 million points. You can get the jet. So here's a certified check for 7 million points. And let's see what the class thinks who should win the case. And notice here, right? The class is being completely consistent, but here's why you always need a lawyer if you get sued, or if you have to sue some. What the court said in the PepsiCo case is no, Pepsi wins. Now that seems to be a complete, is this like the abortion case where they just overrule their own precedents? No, because what the court said in PepsiCo, what the court said in this case is that the offer has to be serious. And it was meant tongue in cheek. This was actually kind of a joke. If you look at the commercial, most people would say they're just trying to be humorous. As evidence in support of that conclusion, when you actually open the PepsiCo catalog for Pepsi points, there was no mention of a jet in the Pepsi catalog, So Pepsi ended up dodging a bullet here and didn't have to pay, the $23 million equivalent of the jet, to Leonard. Even though, if you apply the logic of, the common law, right? But common law, this is the thing about common law, it's incremental. Each case builds on a previous case. And the common law is unique to each state. That's why in New Zealand, in Zimbabwe, in India, England, in Massachusetts, in Florida, you're going to have minor variations in these general common law rules. And this case, the PepsiCo case, was decided in New York State. And in New York State, the offer has to be serious. So, is $1,000 a serious offer for a pet? Probably is, because those of you who have dogs or cats and have a pure breed know that these animals can actually be very expensive. They can be worth several thousands of dollars, for example. Now, this leads me to the Tiger King. What about Joe Exotic's reward offer? And actually, in the new season of Tiger King Part 2 that came out a year ago around this time, the family of Carol Baskin's second husband, who had disappeared, right? They actually increased Joe Exotic's reward offer from $10,000 to $100,000. Remember, all this occurred in the Tampa area. So if you know what happened, to Carol Baskin's second husband, you could cash in on $100,000 if this is legally enforceable. So here, what I want to ask for the class is this Joe Exotic reward offer. is it serious? Is it, you know, is it more like a reward, you know, for a pet? Which most likely is serious. You know, people love their pets so much, they're willing to offer a lot of money, you know, as a reward. And as long as they put a definite dollar amount, that's going to be legally enforceable. Or is the Joe Exotic reward offer, you know, to get Carol back, for Carol Baskin's arrest? By the way, what makes this reward offer so interesting is that when Joe Exotic first made the reward offer, although it was only for $10,000, it wasn't for, you know, Carol Baskin being convicted. It was if she's at least arrested, you know, not even charged, just arrested, you know. So that raises an interesting public policy issue. Can you actually give a reward offer? Is this serious, or is this more like the PepsiCo case? You know, that is not meant to be serious. And this, to me, actually, it's very hard. I'd be curious to see what the class thinks. And if you see here, we've gone from, you know, the 76 and 70, 90, you know, what was it up here for C? 35%. You know, we've gone now to 60%. And this one, you know, if we were to ever, now, what's interesting is Carol Baskin has not been arrested yet, right? This is supposedly a continuing investigation, as far as we know. But there has been no arrest in the disappearance of Carol Baskin's second husband, and so Don Lewis. And so, you know, this hasn't been tested in court yet. But this, to me, actually is an interesting question. You know, now you'll notice that it's Ripper Jack. He's this YouTube, I don't want to call him an influencer. I think he's like a private detective, and he has a YouTube channel. And so now we have to do more investigation into Ripper Jack. You know, is he being serious here, or is this guy is this just a publicity stunt? You know what I mean? You could say he's being serious because when Carol Baskin was on Dancing with the Stars, Ripper Jack and the family of Don Lewis paid a lot of money to put these ads on ABC, on national primetime television, you know. But then again, so did Pepsi, right? They played, you know, this was halftime in the Super Bowl when they put this ad for the first time, you know, so they paid even more big bucks, and that was not dispositive as to the seriousness of the offer. But you can see what I'm trying to teach you here is, in one short class, is how the common law evolves and how you have these gray areas, right? Because here, how do we decide if something is humorous or not, if something is serious? That's a general standard. That's not a bright line rule, right? And so that's going to create these kind of situations here. So we'll see what happens here. I'm inclined, if you've watched Joe Exotic, you know, Tiger King, or season 2 of Tiger King, I'm not requiring it, but, you know, if you have watched it, you know, if I were the judge, I would say this was serious, you know, that they in fact are, you know, this is a serious offer. And if Carol Baskin does get arrested, they're going to have to pay out the $100,000 to whoever provided that information. All right, I think we have a couple more survey questions, and I now want to teach you about tort law, the last major area of the common law. And here it's there's a case I assigned from Florida involving cattle trespass. This is one of the most famous examples of all, because what you have here is a dispute between a rancher and a farmer that's happened many times. The problem is the problem of wandering cattle. If you're a rancher, right, you own some cattle, some cows and bulls. What if they trespass onto your neighbor's land? And if your neighbor, like in the case I've assigned, is a chili pepper farmer, and your cattle trample all of the chili peppers or some fraction, you know, of the chili pepper crop, right? Who pays for that damage? Or to put it more generally, you know, what rule do we want, or do we want a general standard? So there's two possibilities here. Let's see what the class says. The class says that the rancher should put up the fence, but 15% says the farmer, it should be at the farmer's expense. Let's see here. Another 21% say, you know, the rancher should compensate. You know, even if there's a fence, regardless of who put up the fence, you know, rancher should pay after all. You know, that's kind of logical. It's your cattle. Notice 1%, 6 respondents said that no, it's the farmer needs to be responsible here, you know. And let me just say something here. Um, there's something called law and economics, which has had a huge influence in the analysis, legal analysis in the last 50 years or so. There are other views. There's like feminist jurisprudence. There's now critical race theory, which I'm not allowed to teach, of the new woke act, you know what I mean? So I'll figure out a way of teaching that maybe in the last module. There's all kinds of different perspectives. But what's interesting about law and economics, it was English economist. His name was Ronald Coase, Coase. And he is the one who made this cattle trespass example famous. And if you read the Florida case that I assigned in the module, what you'll see is the common law had historically adopted a bright line, simple, clear-cut rule called strict liability. This is the cattle trespass rule of the common law. The rancher is always liable for all the damages caused, by his cattle. It's his cattle or her cattle, if it's a girl rancher, if you will. So it's the rancher's responsibility. And that seems to be the class's intuition. What Coase did that was so novel is he said that if you want to look at this from a philosophical perspective, you could say the rancher's just as much liable as the farmer, because, if you're a rancher and you have crops that could be destroyed by cattle, and you know that your neighbor has cattle, right? Then why don't you take the precautionary steps to avoid damages to your crops? Why don't you put up the fence then? Why don't you pony up? By the way, my professor when I was at Yale, Bob Ellickson, went to famously, this became a very famous study he did. He went to Shasta County in Northern California, which happens to have a lot of neighbors who happen to have cattle and crops. And what he found out there is that what they normally do, it doesn't matter what the law is, they will each pay 50% the cost of a barbed wire fence, so that people will solve their problems without law. But what happens if neither side wants to pay for the fence? What should the rule be? And what Coase did that was so novel is he said, if you're a judge, you should think, what if the farm and the ranch were owned by the same business person? That business person will figure out what is the optimal mix of cattle or crops, what's going to make him or her the most money, basically. And then that's the rule that you want to emulate. And let me tell you, that revolutionized the law. What Coase did is when he studied cattle trespass, is he realized in many places, including Florida, like that case I just gave you in the module, the common law bright line rule of strict liability was replaced with legislation creating a general standard, the standard of negligence, that you only have reasonable steps to avoid foreseeable harm. Once you have negligence rule, and by the way, the negligence rule is what generally applies to most torts and accidents, unintentional accidents. This is like, those John Morgan ads, you see Dan Newland, they're basically litigating the negligence rule, you have to take reasonable steps to avoid foreseeable harms. You have to drive carefully, and so that we have to decide on a case by case basis, whether what you did was reasonable in order to avoid a foreseeable injury. What is foreseeable and what is reasonable? Those are classic general standards. And generally, that's not what applies. Legislation has in many areas displaced the common law. And this is one example of that. So a lot of injury and accident law has been displaced by legislation, including federal legislation, such as if you're injured by a pharmaceutical product, probably you won't be able to sue under state tort law. You're gonna have to sue under federal, drug laws, drug safety laws, and those will displace. The Supreme Court has ruled in previous cases. So that's why the larger lesson here is you always need an attorney if you're going to be sued, or if you need to sue somebody else to vindicate your rights. Because first of all, the attorney will be able to know, does the common law apply here? And if so, what is the common law rule? Or is it a general standard? Or has the common law been replaced by legislation? And if so, member sources of law. Is it international, Is it a federal law or is it a state, legislation by the state house in Tallahassee, for example? So that's, sort of like connecting what we just did with our previous lab. Let me see. I think there's one more survey question. So let me just go back in the screen share and let's see here. Oh, no, that was the last one. Okay, so I thought there was more. So let's see. Oh, so let's talk about illegal agreements then. That's the bonus part of the module. So I'll go back to the module and I'll go to the discussion post. Many of you have already done the discussion post. If you did the discussion post before the storm, I already graded it. I was really impressed with the quality of the work, gave full credit, but let me show you how you can argue this on both sides. So we'll go to the discussion post. The quiz for module C, it's open book, and what I talked about today, you should have no trouble. Here, this has two parts. What does Oliver Wendell Holmes mean about the common law being based on experience and not logic? And I gotta say, that's an open-ended question. That is, to me, and really to most legal scholars, that is one of the most haunting definitions of the common law, that is based on experience, not logic, And I will tell you, Holmes himself, it was a book he wrote in 1881 when he was still a law professor at Harvard before he became a famous judge. And he basically said, look, common law, judge-made law, like legislation, is designed to solve the social problems of the day. And that's why the law evolves over time. Maybe common law evolves slowly because we're deciding things case by case, and we have to respect precedent. We have to respect, generally speaking, how previous cases were decided. That's why, again, the Dobbs abortion case is so controversial. From a legal perspective, putting aside the merits, of the underlying abortion question. But my second question is about human vampire contracts. And I know from the academic activity, we also have a lot of fans of Twilight, and I consider myself, I'm going to be honest with you, now, whether you're Team Jacob or Team Edward, we could have debates about that. But what I found so fascinating about a lot of the vampires in Twilight, is that, they are ethical vampires, right? Some of them will only consume the blood of animals, to avoid, quote unquote, infecting, humans. And so that really blew my mind because the way vampires have historically portrayed, whether it's Buffy the Vampire Slayer or, the original Dracula, Bram Stoker Dracula, and everything in between, is that vampires are these evil creatures. So I wrote this chapter for a book called The Law and Economics of the Undead. And maybe vampires aren't so bad after all. Maybe the reason why they're bad is because the law doesn't recognize, doesn't legalize blood sales. And this is actually a very controversial question. I will just tell you this right now, just to link it up to current debates. Most people would say that the sale of human organs should be illegal. And in fact, Congress in 1984 enacted a federal law called the National Transplant Organ Act, which makes it completely, it's a federal crime. It's illegal to sell human organs. What's interesting, though, is that if you look at the market for reproductive material, by this I mean, male sperm and female ova, that actually, people buy and sell that all the time, through these fertility clinics, right? Why? Because the National Transplant Safety Act actually has an exemption for reproductive material. And so this raises a really interesting question of where do you draw the line? Where does blood come in? Is blood more like reproductive material, where the law recognizes that it can be, you can buy and sell your genetic material? Or is blood more like human organs, where most people, and the law included, would say, no, that's completely illegal, right? What's interesting is that blood is excluded from the definition of sale of human, or a definition of organ and tissue. However, the World Health Organization, which became very prominent during the COVID-19 pandemic, the World Health Organization recommends that the sale of blood be illegal. And some countries, like the United Kingdom, where our common law tradition comes from, have actually enacted legislation prohibiting the sale of blood. Other commentators have noted the pure hypocrisy of this position because it's actually, the Red Cross, which is the major collector of blood donations, right? They're allowed to sell the blood they connect to hospitals. Like, they don't give that stuff for free, So, and now there's been blood plasma sales, et cetera, in that gray area. So I wrote this paper that we have this gray area precisely because property rights, that's my position, precisely because property rights are not well defined in blood, either to allow or disallow blood sales, is that you have all this violence in the vampire world. Now, of course, all of this is tongue in cheek. I am really thinking here about other illegal substances that, you're not allowed to buy and sell. But the larger point is, whether you agree with me or not, it's perfectly fine. This is just a thought experiment. Obviously, vampires are not real, or are they? But let's just assume they are fictional creatures. Here, I want you to think of, when, because another requirement for a promise to be legally enforceable is that the promise has to be for a lawful activity. Illegal agreements cannot be enforced, generally speaking. Now, there are some exceptions, which you would learn in law school or in a bar prep course, but the general rule is, like Breaking Bad, contracts for the sale of meth, crystal meth and other illegal substances, won't be enforced in the courts of law. And so where does blood fit in? So that's what I'm asking you to do there. And what's fascinating about the common law is, moral philosophers, address these kind of questions. But I personally, as someone who studied both moral philosophy and the common law, I am marveled at how sophisticated the common law is in providing answers to these difficult moral, dilemmas. When do we enforce a promise? When should a promise be classified as illegal and therefore unenforceable? And now you also know, after this class, however you answer that question, and one of the reasons perhaps the common law is based on experience and not on logic is because sometimes we adopt bright line, simple, clear-cut rules to answer these difficult moral, legal, ethical questions. Other times, we adopt general, flexible, broad standards in order to address these controversies. And that's why the law is so contested. Think about privacy rights, and does privacy include a right to abortion, as was the original precedent in Roe versus Wade, right? That's a general standard. How do you define privacy and a privacy interest, right? And how do you expand that to include decisions about your health and your reproductive autonomy, those kind of things. And so, but that's what I think makes the common law so great, is because it provides us these tools. You just saw, with property rights, just to get our takeaways, you just saw that, ownership is a bright line rule, first possession, when it comes to something that's never been owned before. With contracts, we saw we have a mix of bright line rules. A promise has to be supported by valuable consideration or bargained for consideration, something of value. In contrast, when is a offer serious, right? That's a general standard, right? In determining that the offer was not made in jest. And finally, when it comes to legal liability for injuries and torts, right? We have sometimes historically, cattle trespass, for example, was a bright line rule, strict liability. Today, it's going to be the negligence rule, which is a general standard. Today, you have to take reasonable steps to avoid foreseeable harms. And so what this means is, when you have a general standard, right, we apply this case. And that's why if you do get injured, you do want to hire someone like Dan Newlin or John Morgan or some other experienced attorney licensed to practice in our state, who will know, how to make a strong case to put you within the confines of the standard. Now, in our next module, what I'm going to do is I'm going to keep this module open for another week, because Section 2 doesn't meet, not this Thursday, we have a football game. I'm sorry, Section 2 meets right after this class. Sections 3, 4, and 5 They meet next Thursday, October 20th. This has been the new schedule I've been given by the university. So what I'll do is I'll open up, you can take a break. I'll take my foot off the gas. I'll open up, I'll give you a quick preview of our next module. It is to me the most important. It's the law of ideas. And so we'll do that in 2 weeks' time. We'll do lab number 3. And then in 4 weeks' time, we'll do civil and criminal cases. That'll be the next to last module. And then I'll announce the optional, again, all of this will be optional via Zoom or in person. I will announce, when that 5th and final lab, just on Facebook today, and what's going on with Tiger King characters today, and the JFK conspiracy theories today. We'll do that in our very last class. Again, thank you for your time and attention. I hope you enjoyed the second lab. And with that, let's go ahead and wrap up. Now,